The air crackled with tension. Jury members shifted, eyes darting between the defendant, a young man, face etched with worry, and the stern judge. A hush fell over the courtroom as the defense attorney, voice booming, announced his next witness, a renowned forensic expert. Hope flickered in the defendant's eyes, a glimmer in the face of despair. His future, his very life, hinged on this testimony, on science proving his innocence. The prosecutor, a seasoned lawyer with a reputation for ruthlessness, rose. Objection. He argued the expert's methodology lacked credibility, a thinly veiled attempt to cast doubt. The judge, face impassive, issued his ruling testimony inadmissible. A collective gasp rippled through the courtroom. The defendant, shoulders slumping, felt the weight of the world crashing down. Hope, so recently ignited, was snuffed out, leaving behind only cold despair. The silenced testimony hung heavy in the air, a phantom of justice denied. It was a stark reminder that in the hallowed halls of justice, truth could be a slippery concept. The defendant, stripped of his voice, was at the mercy of a system that felt increasingly arbitrary. His fate, once seemingly within reach, now teetered precariously on the edge of a knife. The courtroom, no longer a sanctuary for truth, felt more like a stage for a carefully orchestrated performance. The law, once a beacon of hope, now loomed like an unyielding monolith, its shadow casting doubt on the very essence of fairness. As the trial proceeded, the absence of the expert's testimony resonated through every proceeding, a chilling testament to the fragility of justice. Every defendant, the law proclaims, has the right to a fair trial. It's a cornerstone of our justice system, a promise etched in legal stone. But what happens when the system falters, when crucial evidence, the very lifeblood of a defense, is deemed inadmissible? The courtroom becomes a battleground, not for truth, but for legal maneuvering. Expert witnesses, armed with specialized knowledge, can sway the scales of justice. They offer insights beyond the grasp of the average juror, illuminating complex scientific or technical evidence. Yet their expertise can be challenged, their findings dismissed, leaving the defendant vulnerable. Judges, acting as gatekeepers, hold the power to admit or reject such testimony, their decisions carrying profound implications. The consequences of barring expert testimony can be devastating. A defendant's right to present a complete defense is compromised, potentially leading to wrongful convictions. Imagine an innocent man falsely accused, relying on DNA evidence to clear his name. Now picture that evidence deemed inadmissible. The very science that could prove his innocence becomes his prison. This is not merely a hypothetical scenario. History is replete with real-life examples of crucial evidence being barred, leading to miscarriages of justice. The case of Cameron Todd Willingham, convicted of arson and murder based on flawed fire analysis, stands as a stark reminder of the human cost of such legal missteps. Willingham was executed in 2004, despite mounting evidence pointing to his innocence. His case serves as a chilling testament to the fallibility of the justice system and the urgent need for reform. The potential for injustice looms large when critical evidence is silenced. It erodes public trust in the legal system, casting a long shadow of doubt. If a defendant can be denied the opportunity to present a full and vigorous defense, can we truly claim to live in a just society? The answer, unfortunately, is not always clear-cut. Preventing such miscarriages of justice requires a multifaceted approach. Judges must be held to the highest standards of impartiality, ensuring their decisions are grounded in law, not personal bias. In this case, the judge donates money to the party wanting the defendant behind bars for political theater. The judge handles the courtroom with extreme bias against the defendant. The judge's daughter is making millions from this political showcase, like a banana republic. How can justice be attained with such political bias? The admissibility of expert testimony should be rigorously evaluated, focusing on scientific validity and reliability, not courtroom theatrics. Strengthening legal standards for expert testimony is crucial, ensuring that only credible and scientifically sound evidence reaches the jury. Moreover, access to qualified expert witnesses should be guaranteed for all defendants, not just those with ample resources. Public defender offices, often overburdened and underfunded, need greater support to effectively challenge questionable scientific evidence. In this case, the Department of Justice is working to manipulate the case, not strengthen the bonds that hold our legal system intact. The fight for justice requires vigilance, a commitment to ensuring that every defendant, regardless of their circumstances, has their day in court. The courtroom drama unfolds not just in high-profile cases, but in courtrooms across the country every day. A fair trial is a just trial. When courtrooms convict people just because of bias, we begin to lose sight of justice. It's a reminder that the pursuit of justice is an ongoing process, one that demands our constant attention and unwavering commitment. We must remain vigilant, questioning and demanding a system that truly lives up to its promise of fairness and equality for all.